Good afternoon and welcome to our webinar today on selecting prosecutors here at the Society for the Rule of Law. I am Gregg Nunziata and I am the Executive Director of the Society. We have a really rich and exciting conversation today, and I'm going to try to get to it as quickly as possible, but just a couple of minutes of background on us. If you don't know us, the Society for the Rule of Law is a national membership organization of mostly conservative, mostly lawyers who really prioritize the defense of the Constitution, the rule of law, and American self-government above any partisan or policy priorities. We are delighted that you're here with us today watching this program. If you are not yet a member, I encourage you to join the Society. We will drop a link for membership in the chat. Please consider joining. If you are a member, please tell your friends to join as well. We really appreciate it. Membership makes all this possible. We fulfill our mission in a variety of ways. One of the principal ways is by hosting conversations like this, both virtually and in person. Our next virtual event will be in about 2 weeks on Tuesday, October 8th at the same time. And the topic for that is restoring the first branch. It's about congressional function and capacity with a really exciting panel. Would love to have you join us for that. Our next in-person event is our annual national meeting, which will occur on the evening of November 13th here in Washington, D.C. There'll be a link for that in the chat as well. Now I'd like to get to our panelists. I want you to know ahead of time that we would love to have some audience questions, and we're going to reserve some time at the end of the conversation for Q&A. The way to get your questions to me is to drop them in the chat. You can do it at any time, and I'll keep an eye on them, and I will pick out some of the best ones and put them to our panelists. Which brings me to our introductions. Our panelists here are all law professors, a couple of whom also have direct experience prosecuting, which I would love to hear about. And I will introduce them in the order they will be presenting. We have Professor Carissa Byrne Hessick from the University of North Carolina Law School. She has a relevant piece. I'm going to drop some links to some of the writings here in the chat as well. Titled Picking Prosecutors, which you may like to read. Next up will be Mark Osler, Distinguished Chair in Law at the University of St. Thomas School of Law. He has several relevant pieces, which we will drop links to. Also, particularly want to highlight, he co-authored a piece in the New York Times this week on Biden's clemency legacy and the use of the pardon power, which has been a topic that has been of a lot of interest to us this year. We've had two programs already this year focusing on pardons and clemency. Please give that a read. And then third, we'll have Professor Lauren Ouziel from Temple University in Philadelphia, the Beasley School of Law. And finally, Zach Price, who's a professor of law at UC Law San Francisco. Thank you all for being with me today. I'm really excited to have this conversation. We're going to start by asking each of you to give us your thoughts on the topic today, and then we'll move on to questioning. But first, Carissa, if you could kick us off.
Yeah, thanks so much, Gregg. And many thanks to the Society for the Rule of Law, both for putting on this particular program and also for inviting me to participate. In addition to my position as a law professor at the University of North Carolina, I'm also the director of something called the Prosecutors in Politics Project, which is a research initiative that studies the role of prosecutors in America's democracy. So as you might imagine, I've actually spent a lot of time thinking about how to select prosecutors. And I should say the reason I spend so much time thinking about how to select prosecutors is because prosecutors have an awful lot of discretion, that is, authority to make decisions. The discretion includes how to decide what resources to use, where to direct resources within the office, discretion over what policies to adopt in the office. And these questions about resources and policies are really important because, as I don't think all Americans know, prosecutors actually don't prosecute a number of cases that they could. They just don't have the time and resources to bring charges and to prosecute all cases. And so the discretion about which cases to bring and which cases not to bring is incredibly important. And we allow sort of this, when we talk about the selection of prosecutors, we're really talking about who are we going to trust to make those very important decisions. And here in the US, we have three different selection methods. We have elections, which is actually sort of the most dominant method. 45 states elect their prosecutors. Then we have appointments. So the remaining 5 states and the federal government, they appoint their prosecutors. And I'm talking here obviously about the chief prosecutor in the office, not every single person who's prosecuting cases, but the person who's in charge of the office. And then we have something that's really quite rare, sort of this idea of an independent prosecutor, a special counsel, or an independent counsel. And the major difference really between each of these selection methods is the different role that democracy or politics plays in their selection, and thus, sort of arguably when they are making these discretionary decisions. And I say democracy or politics because I think sometimes we fall into the trap of talking about democracy when we really like to have public input, and when we don't want to have public input, we talk about it in terms of politics. So that's how we signal if it's good or bad. If we think it's good, we say democracy. If we think it's bad, we say politics. I'm inevitably going to fall into that same rhetorical trap, but I just wanted to point it out for us. So elections are obviously the most democratic method to select prosecutors. The voters are making decisions. Appointments are only indirectly democratic, where someone who is elected decides who will be the chief prosecutor. And then the special counsel, independent counsel model is supposed to be really insulated from politics and democracy. And I'll say though, right, you might think, well, if you like democratic control, then you should support elections. And if you want to have insulation from politics, then you should select appointments as the selection method. But the truth is, that's sort of how things ought to play out in theory. How they actually play out in practice is a bit more complicated. So the democratic inputs into selecting prosecutors actually aren't nearly as good as we might hope. Most elections for prosecutors are uncontested. So research that we've done at the Prosecutors in Politics Project shows that 70% of prosecutors never face an opponent in either a primary or a general election. So they're entirely unopposed. Voters have no choice about who will be their district attorney or their state's attorney. Even when voters do have a choice, they often lack information that would be necessary in order for them to make sort of informed decisions about who their prosecutor ought to be. Now, in recent years, with the rise of the progressive prosecutor movement, we have seen some talk from candidates about policies that they might adopt or ends that they might pursue, but those are really the exception rather than the rule. And even when you have candidates who make those sorts of statements, my review of those policies actually suggests that they're only talking about a set number of decisions that they'd have to make. They're really not giving the full picture of how they'd use their discretion. Political insulation is actually not really all that robust if you think about the appointments model. That is to say, whether decisions by prosecutors are insulated from politics will really depend on who's in those offices and who. Those of us who are my age, you might remember the U.S. Attorney's firing scandal under George W. Bush, widely seen as an attempt to influence the prosecutions that were 2021, when the White House made clear to him, or made it known to him, that he was going to be fired for failing to bring election fraud cases that would have benefited Donald Trump in the days leading up to January 6th. Even I think when it comes to the special counsel and independent counsel model, which are designed to try to insulate prosecutorial decision-making from politics, Whether that happens in practice is maybe not the same as what the public perceives. Unfortunately, I think if you ask committed Democrats, they will tell you that Ken Starr's investigation of Bill Clinton or David Weiss's recent prosecution of Hunter Biden, they'll insist that those were political. If you ask a lot of Republicans, they will say that Robert Mueller's investigation and Jack Smith's investigation of Donald Trump are very political as well. So I don't, by the way, I'm not suggesting that there are easy answers for what the selection method ought to be, even though I've thought about it quite a lot. I think that there are serious benefits and drawbacks to each method of selecting prosecutors. And even if you think you've balanced the benefits and the drawbacks in theory, what happens in practice might actually frustrate that.
Thank you so much. Next up, Professor Osler, Mark.
Yes, thank you. And my background is that I was a federal prosecutor in Detroit from 1995 to 2000. Then taught for a couple decades, although, Chris, interestingly, in the middle of that, I did an extended interview with Ken Starr for Waco magazine. And we talked a lot about his service as a special counsel. And then last year, I took a 1-year leave of absence from my work here at St. Thomas to serve as the deputy county attorney, which is the DA here, in charge of the criminal division. So I had about 150 people working for me. And that's a county that covers Minneapolis and its western and some of the northern suburbs. There's a couple things that I really was convicted of last year. And one is that locally elected prosecutors do embody a couple important values. And one is local control. That in many states in our country right now, we basically have two political cultures that go on. We have one or two big metropolitan areas and then an outstate area, pretty much everything else, that often votes different ways, definitely has different cultures relating to criminal justice. And what local control allows is for the culture of those places to have a role. When I lived in Waco, Austin was very different. And we certainly wouldn't want people from Austin deciding, how discretion is being used in Waco or vice versa. And it does allow for play there. The second thing, too, that it allows is a much stronger role for current democracy. And what I mean by that is that many criminal laws are sticky. Even after we've turned against them, they're not gone. The fact that marijuana is still a Schedule I substance in the federal code, the way that the crack powder disparity hung on after it had been basically rejected by everyone. And by having locally elected prosecutors, we allow democracy to have a more direct impact on kind of those current issues. It's a more current democracy, and that can cut both ways. For example, if you have a rise in carjacking, something we saw here, local prosecutors can find creative ways to charge that so that there'll be a greater deterrence level than would have been achieved otherwise. Second thing that I want to point out is that when we talk about selecting prosecutors, I think it's important to consider deselecting prosecutors. That is that there's been a big cultural change since I became an assistant U.S. attorney. There weren't really that many career prosecutors. People did it for 5 years, like I did, sometimes 7 or 8, and went and did something else. And I think that there's real value in that model, in that one thing that happens is that criminal law is so infused with tragedy. It's all tragedy. And that creates a formation of ways of processing that don't create secondary trauma. And that's not good. It's not good for justice. It's not good for society. They don't see the victims anymore. You don't see the defendants in the same way. And that's problematic. Finally, I do think that often we pay too much attention to the people at the top. One thing about working for here, a progressive prosecutor, is that the culture of the office often matters as much as the views of the person at the top. If a progressive prosecutor comes in and wants to change everything, it's like turning a battleship, and it's not going to happen. And as much as that new boss is going to influence the staff influences the boss too. A lot of people will pay attention to what happened in Philadelphia. There's a lot of other cases where the incoming progressive prosecutor became less progressive over time because of the effect of that cultural weight of the staff that they inherited. Thanks.
Thank you very much. And now can we turn, I think, to Professor Ouziel.
Hi. So thanks so much for having me here. This is a great conversation. I'm going to sort of segue our conversation a little bit to a related topic in the selection of prosecutors, and that's to when, thinking about how we select prosecutors, I think it's useful to consider the inputs that go into that selection process. So what exactly does the public know about what prosecutors do? And for that matter, right, an appointing official such as a governor, right, what do they know about what prosecutors are actually doing on a day-to-day basis and the decisions they're making? And how does that knowledge, or more likely the absence of knowledge, impact how we select prosecutors and our concerns about rule of law issues? So I think it's helpful to think about the prosecutor's role in two stages. So you all remember like the old Law and Order shows where they did that like boom introduction in our system. There's the police who investigate crimes and the prosecutors who charge them. That's sort of right to some degree. I think there's more prosecutorial involvement in that first stage. And so I think what's helpful is to think about the process in two stages, right? The pre-charging stage and the post-charging stage. And prosecutors are actually quite pivotal in both. And they're quite pivotal in more ways than I think lay folks recognize it, right, in the pre-charging stage. But we as the public really only have insight into the second stage, right, the post-charging stage. But it's the former stage, the pre-charging stage, that has the largest impact on what our enforcement patterns look like and what even our outcomes look like at the back end, right at the end of that second stage. And that's because at the pre-charging stage, prosecutors are deciding who to charge, what crimes to charge, who to target, what crimes to target, what neighborhoods to focus on, and conversely, who not to charge and what crimes to decline. And so that largely sets the parameters of the post-charging universe that we see. And so I think if we understand the work of prosecutors in that way, the question of that how question of prosecutorial selection becomes in some ways, I think, subsidiary to the what question, like what are we exactly selecting for? And what would greater transparency at the pre-charging stage, how would that affect the prosecutorial selection process? Would it improve it? Would it degrade it? I tend to think, although I think it's a complicated question and there's no easy answers, I tend to think generally that greater transparency would improve prosecutorial selection, both for elected and appointed prosecutors. But I think in speaking about transparency, it's important that we really think about and articulate what transparency means. So we can think about sort of full transparency and genuine transparency as opposed to partial transparency and what we might think of as more performative transparency. So what do I mean by this? Well, Carissa referenced in her introductory talk this idea that, right, with progressive prosecutors who are talking about being more transparent in their policies, that's a little bit misleading in the sense that we're really only seeing a very small window into certain policies with respect to certain crimes, and we're really not getting the full picture of what their policies are or preferences are with respect to the whole host of crimes that come across their desk. And I think that's certainly true. It's a really valid criticism of these categorical non-enforcement policies. If we think about it, not only are the categorical non-enforcement policies really partially transparent in the sense that they only give us insight into a select category of offenses and how prosecutors would handle that category. But they don't really allow us to see whether prosecutors are following through on those policies without sort of opening the window into actual declination data, such as bulk data, obviously, number of cases declined, charges declined, demographics have declined, individuals. And so it's hard to know really what effect a given announced policy would have in making any actual changes on the ground. It's hard to know if these policies actually change anything from how what the practice was like before they were announced. It's hard to know if they're being followed. And then again, most importantly, we really have zero insight into enforcement and declination practices with respect to the vast majority of other crimes that are not on these small non-enforcement or under-enforcement lists. So that's just one example of thinking through transparency and how it looks and how it can be a little bit elusive and a little bit misleading. So, to sum up, I think how we select prosecutors is important, but I agree with Mark that politics impacts both elected prosecutions and appointed prosecutions. And so I think thinking a little bit more about what we are selecting for and what inputs we have to make that decision is really helpful in the discussion.
Thank you. And then last but not least, Professor Price, I think he's going to speak in particular more about non-enforcement. So please.
Yeah, well, thanks very much. First of all, let me echo the thanks to Gregg for organizing this great discussion, for including me, and thank everyone in the audience for being here. So I was going to say a few words about prosecutorial non-enforcement, in particular, this phenomenon of what's often called categorical non-enforcement policies, these policies that overtly disclaim enforcement of particular laws in some or all cases. I think as folks are aware, this become a more salient, more common practice. There are some high-profile federal examples, particularly in the Obama administration with marijuana immigration, Affordable Care Act. It's since become a kind of common tool of self-described progressive or reform prosecutors. So I should say, I think it's it's aligned at the moment with progressive politics, but you could imagine it being employed in other ways as well. But what I wanted to address is are these policies, first of all, lawful, and second of all, do they comport with the rule of law? And I'll suggest that I think the answer to both questions is really it depends. I think with respect to their lawfulness, the answer depends partly on the selection method that's our topic here. It depends on the kind of laws and arrangements governing prosecutorial functions. And with respect to the rule of law, I think it kind of gets at some ambiguities in what we mean by that concept. So on this question of lawfulness, I think the first thing to say is that this type of announced categorical policy is a way of stripping force from governing laws. And that's why people do it. And I think that's true even if, as Professor Hessick was describing, I mean, normally laws can't be fully enforced. Prosecutors are exercising a lot of discretion, but they could do so in other ways. They could exercise discretion in a more case-by-case fashion. They could have internal guidelines without announcing them. They could announce them, but frame them in kind of non-binding priority setting terms. So the choice to kind of make a more definitive general policy and announce it to the public is a way of kind of providing greater certainty about how the law is going to be applied, which could mean that it invites violations, gives people more of a kind of green light. So I think that's the in some ways the point and what drives the debate. And I think given that reality, I've argued that that type of policy should, as a general matter, not be lawful within the federal government. The federal government has a unitary executive branch. The president is supposed to ensure faithful execution of the law. And I think it is hard to square that with this type of kind of deliberate undermining of the laws you're supposed to be trying to execute. I think that view comports with a range of considerations, the original understanding, but also a lot of subsequent practice and even some kind of contemporary case law, I think generally supports that outlook. But at the state and local level, I think the answer is more complicated, and it's because of what other folks have been talking about, which is that in most states, local prosecutors are locally elected. So in other words, most states don't follow that type of model with a kind of unified executive branch that's charged with faithfully executing the law. Instead, they have often multiple statewide elected officials, and then beyond that, local officials who are in charge of prosecution or other local law enforcement functions. So I think that complicates things because that type of structure could create an inference that local prosecutors are supposed to be applying statewide laws, as Professor Osler was suggesting, in a manner that accords with local preferences. So, in other words, it could undermine that inference that state executive officials are supposed to be ensuring a kind of uniform enforcement of state laws in the same way that's true within the federal government. So, I think that general inference is there, but ultimately, it really depends on how exactly the state chooses to structure things, and it turns out there's a lot of variation. I have an article that goes through all the states in some tedious detail if you're interested. But the short answer is, I mean, there's just a lot of variation. So to give two examples, California's constitution imposes a duty on the state attorney general, quote, to see that the laws of the state are uniformly and adequately enforced. So that seems designed to preempt kind of local variation, make sure that state laws are given uniform effect. On the other hand, Texas gives the state attorney general no power to assume control over local prosecution. The state's highest court for criminal matters has said that, quote, the attorney general has no authority to independently prosecute criminal cases in trial courts unless there's some special situation. So as a practical matter, that means local prosecutors are going to be able to adopt varied approaches, and it arguably invites the inference that that's part of the structure that the state is trying to set up. So in short, I think when you're thinking about the lawfulness of these policies, we should be answering the question by looking at those varied state laws regarding local prosecutorial authority, and we might arrive at different answers in different papers. So that's the kind of the lawfulness question. Now, what about the rule of law? And so I think some people might be listening and think, well, this isn't how it works. Like even those two examples, right? In California, it's, the statewide officials are perfectly happy with a lot of local non-enforcement, whereas in Texas, they're most certainly not. And I think that reflects that our debate has not actually been structured around these kind of points of state constitutional law, but instead more kind of abstract concerns. And here you get kind of competing rule of law arguments. You get some people saying, non-enforcement undermines the rule of law, right? The law is the kind of the enactments of the state legislature. The prosecutor is supposed to do their job, right, by giving effect to those laws. On the other side, progressives will say, well, it actually advances the rule of law, given that we have discretionary enforcement to ensure consistency, be transparent about what you're doing. Those are rule of law values. And so these kind of overt binding policies are a good way of achieving those goals. So I think the trouble with framing the debate this way is that both sides have a point. I think both those points are valid as a kind of abstract matter. And so I think the rule of law is a really important concept in general, right? It's an important feature of our society, but it gets very slippery in application to these very specific debates. And I think ultimately it doesn't help all that much here, and be better off focusing on those kind of specific arrangements that vary state to state in thinking about whether these policies are what prosecutors should be doing. So I'll stop there, but really looking forward to the discussion.
That is great. Thank you all very much. Maybe we should first just do a kind of a quick round of everybody and see if the comments of your colleagues have led to further thoughts. Professor Hessick.
Yeah, the thought that I was having is actually when you read about prosecutors and what they're doing in the media, sometimes everything seems very black and white. And yet I walked away from, or sat here still after listening to everyone and sort of ended up where I have sort of where I've found myself after looking into it, which is that these things are incredibly complicated. I don't think that there are right answers here. It's so much of it is a question of framing. And once you get into a realm of where sort of structural con law or deeply held views about democracy and those sorts of things don't give you clear answers, I find it sort of impossible not to see the current debate about prosecutors and democracy and politics to be anything other than really a fight about decisions that are being made in individual cases or involving individual crimes. I hope that doesn't sound too cynical, because at the same time, I'm incredibly grateful that everyone engaging on these questions is so thoughtful about them. I mean, and by that I meant the people who are engaging from a legal perspective and not the sort of what bomb can I throw about what a local prosecutor is doing that I don't like.
Right. Professor Osler.
Yeah, just picking up on Professor Price's point about rule of law. It's funny the way that, my job last year was approving charges. And certainly the law as it's written is a baseline. But from there, you're trying to achieve goals and largely public safety. And how are you going to get there? And so I think sometimes people use the phrase rule of law as if it's the end of the discussion. But functionally, in this project of criminal justice, it is a baseline, and there's a lot of discretion that comes after that. One of the things that plays into this too is that this is a discussion that in our field people have over and over again, is that tension between uniformity, which rule of law, as some people conceive of it, is, and discretion. And that plays out in so many different ways. There's this back and forth that has gone on, for example, in the federal system, over 4 decades now. Mandatory guidelines, those are decayed by judges. The Feeney Amendment snaps back, and then the Supreme Court comes down with Booker and gives judges more discretion. It's like watching a ball in a cup roll back and forth. There's almost this constant interplay between those two things, and that's important. I mean, the truth is somewhere in that balance in between discretion in uniformity.
Professor Ouziel. All right, please, you're muted.
Got it. So I echo Carissa's point about right, the complexity of all these issues. It's not, none of it's easy. And I think I want to sort of direct everyone's attention to something that Mark said that I think is really worth focusing on, which is that these decisions are not just made by the person at the top. And in fact, the person at the top, right, is in a dialogue really with not only the people in their office that are non-elected and non-appointed career folks, but also with the people outside their office that they're working with almost as much on a daily basis, which is to say law enforcement agents, whether it's federal agencies, if you're in a federal prosecutor's office, or local police. And then also by the constituencies, right? The public views change, right? There's public preferences ebb and flow. And then there's pressure from state constituencies, right? Like state legislatures, from city councils that are involved in funding, states involved in funding as well. At the federal level, right, there's pressure from Congress that's involved in appropriation. So it's very complex. There's not a through line between this idea of choosing a prosecutor, whether it's by election or appointment, and having a responsive system. It's right? It's very dialogic across a lot of different institutions.
Professor Price.
Sure. I was just thinking something to add to the complexity is there's also kind of a dynamic interplay between the scope of criminal law and the scope of discretion. So one account of what's happened is we sort of ended up with very broad prosecutorial discretion because legislatures in the sort of tough on crime area from maybe about the 1960s to 1990s, at least, legislatures, wanted to be tough, but they could count on prosecutors to, exercise some forbearance, particularly in cases where the public might be upset with charges, so they could kind of freely enact really broad laws and then count on prosecutors to exercise some restraint. But everyone was sort of pushing in a kind of pro-enforcement law and order direction. And part of what's happened since then is that I think the politics of crime have gotten more contested and more complicated. There's some effort to dial that back, but to varying degrees in different places and different constituencies. But here too, like then, is prosecutorial leniency a good way of doing that? Can be complicated because on the one hand, that's a way of kind of updating the law to reflect current preferences, but it also kind of can create that same mutually reinforcing problem that kind of lets the legislature off the hook for what would be more helpful ultimately, which is kind of updating the actual laws in the books rather than just their application on the ground.
Thank you. I will start asking some of my own questions and working in some. We have quite a few questions from the audience as well. I will try to direct questions to individual people. Maybe I will give some just to the room. Feel free also to interject if you have a relevant point you'd like to add to a discussion. First, Professor Hessick, I just was interested in the statistic you had about how often, maybe you said 70% of elected prosecutors run unopposed. That seems surprising. Being a elected prosecutor seems prestigious, consequential, and maybe a rung on a ladder to other political offices. So do you have a sense for why it's so that these are so frequently uncontested?
Yes. So I think there are a few different reasons that this happens. We took our data because it seemed so surprising and worked with some political scientists to see if they could do a statistical analysis that wasn't just me looking at a spreadsheet, looking for things that correlated. So there are a few things that seem to drive this. One big driver is population. Because so many states elect their prosecutors on a county by county basis, there will be many counties in a state with very small populations. Now, some states have dealt with that issue by combining counties into prosecutorial districts. I think 15 of the 45 states that elect, I might have that number wrong, but I think 15 states combine them into prosecutorial districts. So here in North Carolina, we have 100 counties, but we only have 40 some odd prosecutorial districts. But even so, some of those districts end up being pretty small because some of the counties have a very small population. And you get into the Midwest, Nebraska, Minnesota, you have a lot of counties with very small populations, and they don't necessarily aggregate. So population's a big piece of it. There's also, though, in addition to that, places that have very big populations, people don't want to run against the incumbent. And this is harder to study. So we know there'll be somebody who's in office for a very long time. No one will run against them. And when they finally retire, there'll suddenly be a bunch of people who want to run for the office. But the incumbency advantage, or at least the perceived incumbency advantage, is very high for prosecutors. Some folks have done some work on this. Ron Wright, who's a law professor at Wake Forest, I think has done a nice job sort of cataloging why people would not want to run against a sitting prosecutor, including who is your pool, really? The people have to be a lawyer. They have to live in the jurisdiction in most states. And then you're probably going to want someone with some experience. And so then you're really just looking at people who are assistant prosecutors in their office who would have to run against their boss, or people who are in the defense bar who would have to run against the office for whom they're always trying to negotiate good deals for their own clients. So real incentives not to run.
Thank you. Um, Professor Osler, having just recently come out of a progressive prosecutor's office, I'm going to ask you a variety of I'm going to ask you to maybe answer a criticism of progressive prosecutors that have gotten in a variety of ways. And this is to put it in very kind of a very layman's terms. Uh, a criticism is a progressive prosecutor is, in a sense, running for the wrong job because a prosecutor is supposed to be about enforcing the law and standing up for victims, but it seems like they're on the other side. What is the answer to this? Both, I mean, just as a practical kind of political layman's answer, and maybe as a systemic answer about how we should understand the job of a prosecutor.
Yeah, I mean, first, to front it, I think if I ran for prosecutor, I'm not sure I would be identified myself as a progressive prosecutor. But I do work for one. One of the things that's subtle, that's different about progressive prosecutors as opposed to some others, and certainly is different than the people you're talking about who have that critique, is they just don't have the same interest in retribution. That is that gut instinct to hurt the people who have committed crimes. That doesn't mean they don't have an interest in public safety. Those two things are different. And the voice of victims is very often one, it has to be taken into consideration, but it's often one that's focused on retribution. Sometimes it's focused on forgiveness. And either way, it can be problematic for public safety. If we have someone who's committed a murder and the victims are saying, well, we, because of our faith, want this person to be forgiven and receive 2 years, that's not in the interest of public safety. At the same time, if we have a 15-year-old and a 17-year-old who decide to rob the lady next door, and the 17-year-old shoots her dead, and the victim's family very much wants the 15-year-old to get a life sentence. Well, that's probably, from what we know, that's probably not right. That that 15-year-old has much more of a potential to change and be a different person. And that so I think that's an important distinction. It's not that progressive prosecutors don't believe in listening to victims. It's that their interest is usually much more in public safety than it is in retribution. And also to put it in the larger context too, the world that we all live in the legal academy, people like me are constantly in conflict with people who are prison abolitionists who and you all know what I'm talking about. There's people who think, well, you're horrible for having worked as a prosecutor at all. They're against the entire project. And certainly, a lot of what I end up doing is standing up for example, incapacitation, that there are people in our society who need to be held apart because of the threat to public safety. And I don't think that's contrary to the way that most progressive prosecutors think. They believe in incapacitation, not so much in retribution for its own value.
Any additional comments? I mean, we've got panelists from San Francisco and Philadelphia, so I don't know if you have perspectives just on the role of the progressive prosecutor and kind of how we should think about it, either as citizens or as academics.
So I'll say, I think, Mark raises a really good point about sort of distinguishing between the ethos of a progressive prosecutor and sort of how they conceive of their role versus what I was talking about earlier, which is specific policies, right? And so I think, we're progressive prosecutors to sort of, and some of them do, right, campaign on this idea of, I want to bring a different approach without saying specifically what that's going to look like in a given case or categories of cases. I think that's in some ways more helpful to understanding how discretion may be exercised. And I think that's, it's important to think about sort of prosecutorial values, right, rather than specific policies, I think is a useful way to think about it.
It seems like, at least from the media, that there have in many cases been tension between progressive prosecutors and the police. Is that a good or a bad thing? I mean, do we want prosecutors to think of themselves as working hand in glove with the police, or do we want some distance, or does it depend?
I think it's a bad thing. I mean,
Yeah.
uh, it's essential that prosecutors and the police have a good working relationship. And when that breaks down, there's real cost to it. And so, I think you're referring, Gregg, to a healthy tension.
Yeah.
That's always going to be there. And one thing to recognize is that that's there for traditional prosecutors as well. There's tension between the police and traditional prosecutors because those prosecutors don't always do what the police want or in the way that they want. But one of the things that's happened is that you do have often the cultural body of the police, and again, not just talking about the police chiefs but the base of the police are reacting to someone coming in who they think is going to not fulfill their mission to completion. And that can really lead to some bad outcomes, just in terms of when something flares up. For example, here in Minneapolis, we had a huge increase in car theft because there was this TikTok video about how to steal Kias and Hyundais that, then suddenly we had, a 500% increase in the theft of those kinds of cars. You need to react to that in a coordinated way between the police and the prosecutor. And that's really difficult when you've got those political divisions creating a wedge.
Mr. Price, when we think about categorical non-enforcement policies, are there structural reasons or rule of law reasons to think about this differently if the decision is sort of in the hands of a prosecutor versus a governor or an appointing authority who seeks to stop enforcing certain laws? I mean, do they raise different questions if someone is elected as a prosecutor versus someone is elected with a more general mandate?
So I would think to answer that, you really should look at the particular state's arrangements. I mean, I think, the history is kind of interesting. I mean, pretty much all states have a sort of faithful execution clause like the U.S. Constitution, but actually, at the beginning of the country, there weren't locally elected prosecutors. It was really a kind of Jackson era reform around the time we started getting elected state judges. Also started.
Yeah, I just started to I did have one question to say that some of this conversation is confusing without breaking down all the different types of prosecutors, and maybe we should have done it up front. So just we have federal prosecutors, we have state prosecutors, we have local prosecutors, and it varies across the country. So it's very hard to be totally systematic about this.
Right. So I mean, but some states, like I mentioned, like California, actually, there's this provision in the California Constitution that was actually sponsored by the future Chief Justice Earl Warren back in the 1930s that says the state attorney general is supposed to ensure uniform enforcement of state laws throughout the state. So some states have that, others have much more autonomy kind of baked into the law. But nonetheless, we tend to, as I said, not debate these points in those terms, instead in terms of kind of policy outcomes and more abstract values. That's a kind of interesting broader phenomenon. I think it's partly that there's much less investment in state constitutional law kind of intellectually, academically than there is in, say, federal constitutional law. And then you also have states like California where, there's not terribly competitive statewide politics. So everyone's kind of gloms onto policy outlook, and then you don't get as much friction between the state level and the local level as the reading the Constitution you might think is supposed to be there. So I think it's complicated, but in principle, because these are hard questions, it would be helpful to have different approaches that might better suit different local conditions or different state politics and kind of see what works and what doesn't. But we tend to have a nationwide debate that doesn't draw those distinctions instead.
You know
When a
what?
state, go ahead.
Just in terms of non-prosecution decisions, a lot of times they're trailing rather than leading. We often think that, oh, well, they've announced they're not going to prosecute fifth-degree narcotics cases, which the neighboring county here, Ramsey County, did during the pandemic. But the thing is, that's not necessarily big news to people in the prosecutor's office because they were deferring those cases anyways. They were sending people to treatment or basically not taking the case as a criminal case already. I'm not aware of a non-prosecution announcement that really was making a big change in what was really being done on the ground already. Now, certainly there's some things, for example, when you've got a new prosecutor coming in, like Larry Krasner, there were some examples of, okay, they're ruling some things out or talking about ruling some things out. But I do think the change isn't as severe as some people imagine.
Yeah, and I'm sorry, I know you want to ask another question, Greg, but I feel like I want to say something about non-enforcement, like sort of categorical non-enforcement policies, which is, I agree they're incredibly controversial and they're controversial for a reason. But I do find myself constantly coming back to one example of a categorical non-enforcement policy that doesn't get much airtime in the US, and that's that there's a conservative Republican prosecutor in Georgia which recently passed a law saying you can't have any categorical non-prosecution policies. It was mostly aimed at some liberal prosecutors who were saying they weren't going to enforce the marijuana laws. He has a policy that he won't bring adultery charges because adultery is still a crime in Georgia. And it's pretty clear why he has this policy, right? People will get mad. They'll find out that their spouse is cheating on them and they'll show up at their office and demand charges. And he and his line prosecutors are able to say, we have a policy, we won't bring this for anyone. Nobody really wants to talk about that non-enforcement policy because it seems like such good sense, because we also suspect that they're being used for other reasons as well. But that just has me, it draws me back to the idea of how much of this is about the structural arrangements and how much of it is, oh my goodness, why on earth has Georgia not repealed the criminal prohibition on adultery? I'm not saying people should commit adultery, but I don't think we think people should go to jail because they're cheating on their spouses.
Excellent.
So one other thing just to add here is the throwing off both those points is sort of do the signals that prosecutors or other government officials send, does it matter? So is it different whether you're just never actually spending the time to prosecute low-level marijuana possession or adultery? I mean, as conventionally prosecutors would have done for a very long time, but does it matter if you actually announce that and kind of give the green light? Adultery, probably not, for better or worse. It's a sort of human phenomenon. And, maybe something like marijuana, people already sort of understood what they could get away with. But as you get into more contested policy areas, those signals might matter. And as an example, on the federal level, something I think about is the Obama administration, when states started to legalize not just medical, but recreational marijuana, they announced this policy that enforcement of state compliant marijuana possession would normally be a low priority. And I actually think they framed it well. It wasn't, a hard and fast guarantee, but it kind of came to be understood and applied in a more categorical way. And, down the street from me, there's a marijuana dispensary that under federal law is a RICO enterprise. Everyone involved could go to prison for very long periods of time. And I just wonder if people would have had the same comfort, taking that type of step if there weren't a sort of announced policy, if it were just a kind of, background expectation that probably you weren't going to be prosecuted.
We had one comment from a viewer in the United Kingdom, which I thought was just interesting. She said, in the UK, we have no mechanism at all to select prosecutors. And as a result, conversations about prosecutorial policy rarely enter into the public sphere at all, even in general elections. I don't know if anyone just had a reaction to that or had done any work on kind of comparative law.
Yeah, so we are the only country that elects its prosecutors that have sort of the actual prosecutorial power. I get phone calls from folks in other countries all the time, especially after like the indictment in New York and the indictment in Georgia were handed down against former President Trump. And they were like, isn't this just so terrible? It's clearly partisan politics. And my only response to that was, I don't disagree with you that partisan politics probably played a role here, but at the same time, the claims of partisanship are no less sort of vehement when it comes to the Mueller investigation and the prosecution from Jack Smith. So yes, electing prosecutors is like kind of like a wild and crazy thing to do on the international stage. But our concern about politics is not just about elections. It runs deeper than that.
Does anyone have a big picture view on independent or special prosecutors? I mean, there's certainly this idea that you're insulating from politics, but you're also funding an office with the mission to get someone or a set of someone's, which seems at least in some tension with the rule of law.
I mean, I don't know. I've always found the rule of law to be slippery, but go ahead, Lauren and Zach. I just
I was going to say there's like it almost reminds me of the Churchill thing, like democracy is the best of the bad options, right? So like when you're in a situation where the option is you can't have a system where political figures are immune from criminal investigation and prosecution, right? That would just lead to total corruption. So if you start from a premise that we need to have some mechanism in place for investigating and prosecuting high-level officials and political actors, then the question is, well, what is the mechanism that's the most immune from all of the challenges of using the criminal process for political ends, right? That's what you want to avoid. And so I don't think that the special counsel process is ideal by any means. I'm not sure there's I personally haven't heard a better option. There were, I forget, it was like a year ago, a draft article came out. I don't think it was ever published. I saw it on SSR this idea of like having a pre-charging jury of former prosecutors composed of Republicans and Democrats that would vote on whether charges should be brought against a public official to try to like immunize I just don't know that you can ever, we're such a polarized society. I don't know that you can ever immunize a charging decision against a high-level political official from allegations that it was politically motivated. I think you just, if it was or if it wasn't, like you're always going to get that allegation from people who see things through a very political lens. And I don't know that there's a mechanism on the prosecution end that can deal with that problem.
I think that one thing about special prosecutors is them only having one or a couple cases is an issue. It's like being in a train instead of a car that can go anywhere. Once it's on that track, it's going to go there. That old song about the midnight train going anywhere, it's not going anywhere. It's going along the track. And just having one case or a few cases is problematic. And it may be a good idea to have standing special prosecutors who are going to handle a number of different issues at the same time, apart from the normal prosecution body.
It's a great thought. We are starting to run close to our closing ringer here, but I saw one question that I should have thought of earlier, which was whether anyone had a reaction to or a comment about the execution in Missouri last night of Marcellus Williams, which was a story in which I haven't followed it closely, but apparently the prosecutors had opposed the execution, or current or former prosecutors, the family members of the victims had opposed it. And does this tell us anything about what we're discussing today, about the role of prosecutors and how they're chosen?
I mean, I'll just say I know people can have a lot of different views about that case. I think it's probably a good idea to not let that decision rest solely in the hands of victims and families. Whether you think it was the right decision or the wrong decision, I don't think that questions of leniency are just supposed to be questions for prosecutors and for victims' families. Once a conviction's been obtained, I really think that that's something that belongs in the courts.
And we are at the hour, so any other closing comments anybody wants to make, I'd invite them now. I won't require them if everyone feels like they've had their say. It was a lot of value, I think, in today's program. So much got touched on, and it reminds me that we need to do more in this vein. I think there are a bunch of little threads here that we just touched on briefly that could easily fill another hour. So I hope to return to these issues. I hope to return to all of you as guests in the future for our programming. So I want to thank the four of you for bringing your expertise and to us today and sharing your time. I really appreciate it. I thought this was a great program. Just before we sign off, I want to remind everybody that we're a membership organization and members make this possible. So please consider going to our website, societyfortheruleoflaw.org, and becoming a member. Our next webinar is on Tuesday, October 8th, on the role of Congress in our constitutional system. And our next in-person meeting is our national meeting, our Rule of Law Summit, November 13th in Washington, DC. This program will be recorded and posted to our YouTube channel, where you can watch it again or share it with friends. Please follow us on Twitter, LinkedIn, and YouTube to keep up to breast with all of our programming. Thank you all very much. Have a wonderful day, and thanks to everybody for tuning in. Good afternoon.
Thanks so much, Greg.